either in this school or in your own studies, that international law has a very serious enforcement problem. And what do I mean by that? So when you study municipal law in all of your countries, one of the first topics that is addressed in the introduction to the concept of law is the concept of the binding nature of the law, and the notion that the imposing of the law is based on a relationship of subordination. You have an authority that is the state, and you have individuals who are subjected to that state's will. And much of public law governs how that relationship is to be developed. And so we have a clear relationship of subordination. And that key relationship of subordination has some elements. We know that this may vary from system to system, but we do know that the authority above the private individual and the private company has the power of creating the law, which is to say that it has a legislative function. We know that the state, a different organ of the state normally, has the power to interpret and apply the law, which is usually served by the judicature of a state. And we also know that there are organs, usually a multiplicity of organs, which are in charge of executing and enforcing the law. So the first shock that you will find when you go into international law proper is that these roles or functions that are typical in municipal internal systems are not present in international law. We do not have a set system of legislation. We do not have a set system of courts, and we do not have a super government. And this brings us to a situation in which it is the state and the state alone, which has sovereignty. It is the state that, along with the other states in the international community, is engaged in a relationship of sovereign equality. It is the state that creates the law through its agreements and its conduct, either treaty law or customary law, etc. It is the state that interprets the law. It is the state that applies the law. And to some extent, it is also the state that enforces the law. And so international law has a deep need or a deep requirement for there to be strict rules and clear rules as to how states are supposed to vindicate their rights before other states. And once we delve into the issues of dispute settlement, the issues of the use of force, and also the issue of countermeasures, which we will address very briefly in this session, you will notice that the rules on the enforcement and the vindication of rights of states vis-a-vis other states are very different from internal law. And this, of course, brings us to a very philosophical question, one that may be best reserved for academics rather than practitioners. But it is the question of whether international law can actually be called law proper. Of course, we know that just because of the fact that the relationship between states in the international sphere is not a relationship of subordination, but rather one of coordination, does not mean that international law is deprived of its legal character. That is to say that, as I mentioned before, the power of enforcement lies with all of the states. And therefore, this brings up the problem of how those powers of enforcement are to be applied in conjunction, or how they are going to, let's say, interplay with each other. So this is the general context in which we will delve into the question of dispute settlement. Because when we talk about dispute settlement and the use of force, we will be dealing with situations in which normally the ordinary relationships between states have failed. And therefore there need to be mechanisms that allow us to bring the situation back into conformity with international law. So I don't know if so far there are any questions regarding that philosophical underpinning. Great. So let's now delve directly into the subject. So the most basic principle in international law, in most people would argue that it is, in fact, its very purpose, the very purpose of its existence, is the peaceful settlement of disputes. So the purpose of international law, seeing it even in an analogy to municipal legal systems, is to be able to establish relationships between states in which any dispute between them does not lead to the resort to force. And so peaceful settlement of disputes comes to have a very, very big importance. And as you will see when you study Article 1 and Article 2 of the Charter of the United Nations, the peaceful settlement of disputes is also one of the basic notions that underpin the whole United Nations system. It is also the basic principle that underpins the functions of the International Court of Justice, which you will be seeing in a subsequent session. And it is, in general, the principle that justifies the existence and the operation of all of the United Nations organs. And because of the fact that the peaceful settlement of disputes is the raison d'être, as I put in the screen, the raison d'être of international law and the United Nations, it is important to examine what it means to settle a dispute peacefully or in a pacific manner, as the Charter of the United Nations mentions. So, as with many other systems of dispute settlement, or rather many other disciplines in international law, the question of peaceful dispute settlement is based on the notion of consent. The states, through these methods of peaceful settlement of disputes, which we will address later, agree to have those disputes being resolved through those methods. So in the first place, this is not an imposition of the law, but rather it is a situation in which the states agree to resolve their disputes in a particular manner. And this element of consent not only underpins the whole system of peaceful dispute settlement, but it also becomes an essential element of jurisdiction, as we will see when we talk about adjudication and arbitration in the international system. So the importance of consent in international law cannot be undermined in this context. And it is in this very context that we find Article 2, Paragraph 3 of the Charter of the United Nations, which tells us and establishes the general obligation, the general principle, that all members shall settle their international disputes by peaceful means and in such a manner that international peace and security and justice are not endangered. We will see that the same language, international peace and security not being endangered, is a language that we will also find in the functions of the Security Council, which has a very important role to play in the settlement of disputes. We also know that this principle has been recognized in other fora. For example, the 1970 Friendly Relations Declaration makes a direct reference to dispute settlement. And in particular, it talks about peaceful, early, and just dispute settlement, which are elements that are also incorporated within the context of Article 2.3 of the UN Charter. And so we have this context. We have this context that disputes between states are to be resolved through peaceful means. This is to mean that those disputes are to be settled between the states through the mechanisms that the states agree that should be employed. But it also means that there must be a dispute between the states. Now, when you study what is the concept of a dispute, you will most likely find some rulings by the Permanent Court of International Justice and rulings that are later taken up by the International Court of Justice, in which it is defined that a dispute is a disagreement between parties as regards a point of fact or a point of law. However, when we look at the substance of what is a dispute in the international system, and here we are not talking about just the legal system itself, but rather the political environment in which that law operates, we will find that there is a multiplicity of types of disputes. And some of the disputes that attract the most attention, or some of the distinctions that attract the most attention, is the distinction between a legal dispute on the one hand and a political dispute on the other. Many attempts have been made both in academia and in the context of ICJ cases to distinguish between these subjects. The legal disputes on the one hand, which involves questions as regards the application of the law to the facts on the one hand, and on the other, the question of political disputes. And in fact, many states, as you will find through your studies, many states have made the argument that in some instances, the International Court of Justice is not competent to deal with such kinds of disputes that are to be considered political. However, this distinction should not be misunderstood, because in the end, every dispute has an element both of law, of fact, and of politics. And that is the very nature of international law. International law is a body of law in which there is a very close and deep connection between the law itself and the politics, the use of force, the employment of policy as a means of advancing the interest of a state. And thus, every kind of dispute will have an element of policy, of politics, and on the other hand, an element of law. And in fact, the International Court of Justice itself has told us in multiple occasions that since every single dispute may have a political and a legal element, the court may well be seized with the legal aspect of the dispute, while other organs, such as the United Nations Security Council, may be seized with the political aspect of the dispute. And so it is important not to overestimate, to say it in some way, to overestimate this distinction between legal and political disputes. So we now have the context in which international law exhorts states to settle their disputes through peaceful means. We know that international law does not impose any particular set of means without the consent of the state. And we also know that these methods come into operation for the states once a dispute arises between them. And so you will see as an underpinning in all of these considerations that we are dealing with a disagreement between states, and usually a disagreement that deals with the interpretation, application, and fulfillment of the law, for instance, a treaty or a customary norm. And thus, in the subject that we will be addressing today, which is dispute settlement, we will not be addressing other kinds of adjudication in the international sphere. For instance, international criminal adjudication, which we will be addressing in the next session. The reason is that the purpose of international criminal adjudication is not immediately to resolve a dispute between interested parties, but rather it is to apply the penal norms that are recognized in international law to conducts that are deemed to shock the conscience of humanity. It is a separate interest, a separate legal interest that is being addressed in such proceedings. And so in this context, we will only be addressing the question of when a dispute arises between states and how those disputes come into a settlement. So before I move to the next slide, is there any question regarding this set of subjects? All right. So now we go into the actual methods of dispute settlement. This characterization or this categorization that you see on the screen is not, let's say, a binding characterization itself. This comes from academic writings, principally from Professor Malcolm Shaw in his book International Law, the edition, 2017. And he distinguishes, at least in the context of this writing, between diplomatic mechanisms and other kinds of mechanisms which are considered to be binding. So in the context of diplomatic mechanisms, we will see that the common denominator of these mechanisms is that it is the states themselves, which are parties to the dispute in question, that solve the dispute. And there are many modalities in which they can come into a settlement. The most common, which we'll find probably in Jessup cases or in real life, is direct negotiation through the diplomatic channels. So this means that it is state A, and this state addresses directly state B, and through a back and forth, they come into a settlement. And it is only the interested parties that come into the dispute to come into a settlement. On the other hand, this is not the only way in which a dispute can come to a settlement. One of the concepts that we see a lot in international law and international politics, especially in the context of the United Nations, is what is called good offices, which is the second option that you see on the screen. So, and sometimes this subject is addressed together with mediation. And in a moment, you will see why. But it is important to distinguish between good offices, mediation, and conciliation, because at least in the mean, they are considered to be separate mechanisms for the settlement of disputes. even if they are related very closely, and they can, all of them appear in a single case. When we talk about good offices, we are talking about a third party that comes into the dispute, not to solve it, not to assist in solving it, or not even to propose a formula for settlement, but only to lead the parties to negotiation. That is to say, to approximate the parties, to approach them between themselves, and to exhort them to settle their disputes through peaceful means. So one of the entities of the United Nations that has a very famous role in operating with good offices, or in the exercise of good offices, is the United Nations Secretary General. In many international disputes, the Secretary General has intervened, not in the capacity of a dispute settler, but rather in the capacity of providing good offices to approach the parties and exhort them to come into negotiations directly between themselves. And as you can see, this concept can very easily translate into other means of dispute settlement. And this leads us to mediation, which, as I mentioned before, is sometimes addressed together. When we talk about mediation, we are not just dealing with a third party that is exhorting the parties to come into a dispute settlement mechanism, but we are talking about a third party that is directly involved in the negotiations themselves and who assists the parties in finding a settlement that is mutually agreeable. So this party does not have the power of decision. It only has the power, or rather the permission of the parties to participate in a manner that is conciliatory. It doesn't offer means of settlement, but only seeks to find a middle ground between the parties. And so very easily, a process of good offices, for instance, by the United Nations Secretary General, can lead into mediation proceedings. And as you will find, there are many rules, which most of them are developed by the United Nations, this office, how is the name? By UNCITRAL, the United Nations Commission on International Trade Law, who has developed rules and guidelines on how to settle, how to conduct mediations, how to conduct conciliation, and even how to conduct arbitration. They have model rules of arbitration, model rules of, rather a model law of arbitration. So, and you will find that many principles that are codified in those bodies of law may also be found in the international sphere, but you should not immediately assume that they are automatically transferable. International law does not mandate any particular method of dispute settlement, and it also does not mandate any particular way of implementing any of those dispute settlement mechanisms. And so it is very common for the states involved in the dispute who have consented to this mechanism of dispute settlement to come into their own agreement as to how the dispute settlement mechanism is to be implemented in the particular case, which means that many instances of disputes between states will be settled by a combination of these mechanisms as may be suitable for the case at hand. And this leads us to the final two kinds of so-called diplomatic mechanisms, which are inquiry and conciliation. I will address first conciliation because it is very closely connected to mediation. When we talk about conciliation, we also have a third party that operates in, as I mentioned before, a conciliatory fashion. But this third party does not only try to assist the parties to find a middle ground, but rather submits suggestions for settlement, which, if the parties agree to, becomes a settlement between them. And so, once again, the third party does not have power of decision. I see that there is a question in the chat.
Yes. Do you want me to interrupt you when there are questions, or should we wait till the end?
No, if you want, you can tell me once I finish each slide if there are any questions in the chat. I will be addressing the question of consent when I deal with binding mechanisms. And this is a very important question. I will read it out loud. The question is consent for a court to adjudicate a case, international customary law, or a general principle of law? So it is a very, very interesting question, and I will be addressing it in a moment.
Thank you.
So we were dealing with conciliation. So as I mentioned, the third party that is involved in the conciliation offers a formula for the settlement of a dispute, And if the parties agree to it, it becomes a binding settlement between them. And finally, we have inquiry. And the purpose of inquiry is not to settle the dispute itself, which is why it's a little different from the other mechanisms. The purpose of inquiry is mostly related to fact-finding. So the parties will normally establish what is called a commission of inquiry. You will find that concept or that wording very commonly in the context of dispute settlement and in the context of even criminal adjudication. A commission of inquiry has the function of finding the facts regarding a particular situation. And this kind of dispute settlement mechanism is particularly important when we are dealing with disagreements as to the facts, because it is a way for the states to come into an understanding of what exactly happened. And when there are disputes as to the law, a commission of inquiry will be very helpful in assisting the parties as to how the law that is applicable in the case will be applied to the fact. And so it is a little different from the other ones, and it has a broader scope. Some are called commissions of truth, commissions of inquiry, commissions of, I think there was a third name that is very common, but I don't remember it at this moment. But yes, so those are the mechanisms that are called diplomatic mechanisms. And this should, by making the comparison between diplomatic mechanisms and binding mechanisms, we should not come to the conclusion that the binding mechanisms are imposed on the states without their consent. And this will, in a moment, lead me to the answer of the question. So this is also based in the principle of consent when we are dealing with binding mechanisms. Well, what binding means in this context is that there is a third party that is an uninterested party that is impartial and independent, that has the function of evaluating the facts of the case, determining the law applicable, and solving the dispute. And so in this circumstance, contrary to what happened in the diplomatic mechanisms, the third party has the power of decision. Now, these binding mechanisms can come in a multiplicity of forms. The most common is adjudication, which is, for instance, before the International Court of Justice, or arbitration. And there is some debate. You will find it in scholarly writings. There is some debate as to what exactly is the difference between adjudication on the one hand and arbitration. And I will be addressing this in a moment. But coming to the question of the principle of consent. So when the principle of consent is addressed in the context of dispute settlement, as I mentioned, it is usually called a principle. And so the most common understanding is that this is considered a general principle of international law in accordance with Article 38(1)(c) of the Statute of the International Court of Justice. However, it is also possible to come into the conclusion that the requirement for consent is a principle of customary international law. And this is because the notion of consent is not a notion that exists on its own. The notion of consent is an underpinning principle or an underpinning notion or concept of international law, which touches many areas of international law. For instance, the principle of pacta sunt servanda, which is both considered a general principle and a rule of customary international law, is directly connected to the notion of consent. So you will find when you're studying the literature in the cases that some jurists, some judges, and some tribunals refer to consent as a principle. Some refer to it as a requirement of customary international law. In the end, other than for purposes of normative hierarchy and problems of fragmentation, which you probably will study at some future point of your career, other than for those purposes, the effect is essentially the same, which is to say that in order for a mechanism of dispute settlement to come into operation, there needs to be consent. And in fact, if you're interested in this subject, there is a very important very important concept that is addressed in the context of consent and general principles. I will try to find the article that I read, and maybe I can send it to you through Claudia. But in some instances, academics distinguish between different kinds of principles, of general principles of international law. And so these academics say that there are some principles that are substantive in nature. For instance, the principle of no harm in the context of the environment. There are other principles that are not in themselves of substance, but rather they are principles that are inherent to the legal system itself. And the principle of consent to jurisdiction is considered to be one of them. So it appears that for many academics, the notion of consent is one that falls within the concept of a principle rather than a rule of customary law itself. But as you can see, the line blurs a little bit. So as to the difference between arbitration and adjudication, there is some debate when dealing with dispute settlement as to whether the International Court of Justice is an arbitration tribunal or a court in proper. And the distinction may be perhaps somewhat academic, but it is an interesting question, because since both court proceedings and arbitration in international law are based on consent, the line that is drawn in private law between arbitration and court proceedings is a little blurred. The notion that is usually employed in this context is that adjudication normally refers to proceedings which are of a judicial character, but which are undertaken before a permanent institutionalized court or tribunal, while arbitration is brought before a tribunal that is constituted by the consent of the parties. And thus there is a little bit more of a procedural flexibility involved. But in the end, the function is essentially the same, which is to say that this third party that is involved in the binding, so-called binding dispute settlement mechanism has the function of deciding the dispute rather than offering formulas for conciliation or mediation. And before I move to countermeasures, which is a very different concept, I would like to know if there are any questions in the chat, because I can't open it.
No, we don't have questions for now.
Great. Okay. Other mechanisms. So this third characterization was added by me to this presentation because, as you will see, and if you have studied deeply the subject of state responsibility, the concept of countermeasures is very closely connected to it. It is not in itself a mechanism to settle a dispute. A countermeasure, as you may well know from the Articles on State Responsibility by the International Law Commission, the countermeasures are a circumstance that precludes the wrongfulness of an internationally wrongful act. And the essential concept is that it is an action that is prima facie considered to be inconsistent with an international obligation, but that is considered lawful because it is taken in response to the wrongful act of another state in respect of an obligation that I was owed to the first state, and that is taken with the purpose of forcing the other state to come back into conformity with international law. So it is somewhat of a self-help measure of pressure for a state to put an end to a breach of international law by another state. And so international law recognizes this concept in within very strict conditions. And it is a method or a mechanism that is at the disposal of states, but which has to be applied within very strict parameters. Which are those parameters? Unfortunately, we will not be able to go so deeply into all of them, but in concept, there needs to be a wrongful act by another state. There needs to be the act that is taken as a countermeasure needs to be taken with the purpose of bringing down breach of international law to an end. The action that is taken as a countermeasure has to be necessary. That is to say, other mechanisms have to be exhausted before that. And in the context of necessity, there is a procedural obligation for the state to notify the other state of its intention to apply a countermeasure. And only after the other state fails to implement the obligation that is breached, then the state can proceed to adopt a countermeasure. And finally, the countermeasure has to be proportionate, not only to the gravity and nature of the breach, but also to the parties involved, which is to say that a countermeasure cannot be taken against a third party, but only against the state that is responsible for the wrongful act in the first place. And this also means that countermeasures, in principle, should not affect the rights of entities that are not in themselves states, but which have rights under international law. For example, there are cases, and you will find them in the commentary to the ILC articles. There are cases in which a countermeasure, so-called countermeasure, is taken in respect of, for instance, an investment protection treaty. And arbitration tribunals have taken the position that since investors have self-standing independent rights from their own states, then the countermeasure should not be able to affect them. Otherwise, the countermeasure is illegal, is contrary to international law. So what is very important in the context of countermeasures is that the measure has to be non-forcible. That is to say, it doesn't have to involve the use of force. And we will see the reason for that later on. So, and to make it very, very clear, as I mentioned, it is not a mechanism for the settlement of disputes, but rather a right that is guaranteed by international law under very strict conditions for a state to vindicate its own rights as a mechanism of self-help. So I don't know if there are any questions in the chat before I proceed.
Yes, there's one question that says, can the justification of countermeasures be used in non-international armed conflicts?
Great question. Very, very good question. Very complex question. So when you see the drafting of the short answer is that the countermeasures, the concept of countermeasure is part of general international law. And if you see Article 55, I believe, of the ILC articles, these general rules of responsibility are superseded by special rules, lex specialis. So when the concept of countermeasures was drawn up by the ILC, they addressed a very closely connected concept, which is the concept of reprisals. The concept of reprisals is very, very, very similar to a countermeasure, but it is taken in the context of international humanitarian law. I will try to address more deeply the concept of reprisals later in tomorrow's session, since I see there is an interest. But in principle, those special rules that are found in international humanitarian law would supersede the concept of countermeasures. Now, there would come the debate as to whether the concept of reprisal is recognized under international humanitarian law in the specific circumstance of a non-international armed conflict, which in itself is also a question that we could debate for hours. But in principle, the concept that is more akin to humanitarian law is the concept of reprisals. I see another question.
Yes, it says if you can give an example of countermeasure.
Sure. There was this example that I gave my students last year, which was inspired by this incident in which the Suez Canal was blocked by the Evergreen ship, if you remember it. So the example that I gave them was what happens if another state breaches an obligation related to the channel. And so the first state decides to, in order to force the other state to come into compliance with its obligations, to close temporarily the channel and to block navigation for that state. So imagine that there is an obligation to keep the channel open, which would be, for instance, in the context of the UN Convention on the Law of the Sea, there may be an obligation to do that. In that case, the first state would be suspending an international obligation with the purpose of forcing another state to comply with its own. There is another example. I don't know, Claudia, if I can give examples of previous Jessup problems.
Yes, anything but 2023 you can do. Yeah.
Great. So there was this debate in last year's case regarding the application of an extraterritorial jurisdictional measure. Basically, the applicant had undertaken enforcement measures in another state's territory, and the action itself could be considered illegal, contrary to the sovereignty of the other state, but it was in the response to a prior intervention by the other state. So in very specific parameters, that could be considered a countermeasure so long as the other conditions are met, which is to say that it is necessary, proportionate, there was a notification that is only directed to the state, etc. And there are some obligations which are not subject to countermeasures. For instance, human rights obligations, the inviolability of diplomatic and consular premises, etc. But in principle, those would be examples of countermeasures. So I think this leads us to, let's see. Okay, so here is when the subject starts to meld a little bit with the concept of the use of force. Because the United Nations Security Council, which, as you know, has the function of maintaining international peace and security according to Article 24.1 of the Charter, the Security Council has a role to play in the peaceful settlement of disputes. And to be clear, we are here not yet dealing with peace enforcement measures in accordance with Chapter 7 of the UN Charter. We are dealing with peaceful settlement of disputes, I believe, in accordance with Chapter 6 of the Charter. So the main purpose of the Security Council is to maintain international peace and security. And the mechanisms that are placed in the hands of the Security Council are varied. The thing that you must understand in this context is that unlike many other resolutions and decisions that are found in the international UN system, the resolutions and decisions of the Security Council are binding in accordance with Article 25 of the Charter. So a decision regarding enforcement measures would be binding. But a recommendation in the context of peaceful settlement of disputes before a threat to the peace has erupted is not a decision in the context of Article 25. It is normally not considered to be a binding decision, although circumstances may vary. So the context in which the Security Council is mainly interested is when a dispute is liable to endanger peace and security, because that is its function, to prevent a threat or a breach of the peace and the security of the world. And so the Security Council has the mandate to study and investigate, as you can find in Article 34 of the Charter, disputes or situations which are capable or liable of leading to disputes. And in particular, this article, I think it is this article that mentions that it has the ability to investigate and look into situations in which there may be a dispute that leads to international friction, or a situation that may lead to a dispute that endangers peace and security. So when this is present, and as I mentioned, there is still not a situation that calls upon the Security Council to use force in accordance to Chapter 7, the Security Council, according to Article 33, Paragraph 2, can call upon the parties to settle their disputes by peaceful means. And those peaceful means are varied, which are essentially what I mentioned before. The Security Council can exhort the parties to come into a settlement, but it cannot force them because they are peaceful means. And in principle, the Security Council can also not settle the disputes for them. I see a question. I will address this at the end of the slide. So in principle, the Security Council cannot settle the disputes for them, unless, in accordance with Article 38, the parties agree that the Security Council can make recommendations as to how the dispute is to be undertaken, is to be solved. So the question that is posed in the chat is how we distinguish between a decision, which is binding, and a recommendation, which is non-binding. So in the context of the UN Security Council, one of the most important aspects, there are actually two important aspects. The first is the legal basis for the decision to be taken, or the measure to be taken. So measures undertaken under Chapter 6 are normally considered recommendations. They're not binding. While decisions undertaken under Chapter 7 are considered to be binding. And so the legal basis plays a role in determining whether the decision is binding or not. The other aspect that is relevant is the language of the resolution or of the decision. If you have seen many Security Council decisions or resolutions in general, which is also common for other UN organs, there are operative words that are in the context of the actual decision taken by the organ, and the operative words tell us what is the value of what is being established in the operative part. So, for example, in the context of the peace enforcement measures in the context of Chapter 7, The Security Council usually uses language which is more direct and binding. For instance, decides, while under Chapter 6, the Security Council will normally use softer language, such as exhorts, recommends, calls upon, urges, but it doesn't force them to do it because it can't. In the end, they are, as I mentioned, based on consent. So those are some factors that may be taken into account. And unfortunately, we cannot get too deep into it, but it is a very interesting topic, and one that in the context of peace enforcement measures, which we will address later, has presented a little bit of a political friction because of how the decisions of the Security Council are to be understood. So I think that does it for this part. And I mean, I placed there also information as to the composition of the Security Council. You have 5 permanent members and 10 non-permanent members. The non-permanent members switch in periods of 2 years, and etc. That is essentially the composition of the Security Council. So up to this point, we have been addressing how international law expects states to settle their disputes. And we see that there is a general principle that disputes should be resolved peacefully. But as we know from the present context, that is not always the case. And thus, we arrive at the question of what happens when dispute settlement breaks down and fails. And then we come into the concept of the threat and the use of force. The starting point for the threat or use of force is the prohibition of such measures, which is found, as you probably very well know, Article 2, Paragraph 4 of the Charter of the United Nations, which tells us that all members shall refrain in their international relations from the threat or use of force against the territorial integrity, the political independence of any state, or in any other manner inconsistent with the purposes of the UN. So here we have a clear-cut provision that tells us that the use of force is prohibited, and also the threat of force is prohibited. So what is so important about this prohibition? So this prohibition comes from a long history of evolution. The use of force was not always prohibited in international law. And in fact, under the previous system, which was the League of Nations covenant, there was no strict prohibition of the use of force. There was an exhortation to resolve disputes peacefully. Then there was a sort of cool-off period, I believe it was 6 months, in which the states should be willing to come into a settlement that is peaceful. But otherwise, there was no general prohibition of using force. The prohibition of the use of force came a little bit before the UN Charter, a few years before the Kellogg-Briand Pact, in which the states agreed that the resort to force and the resort to the threat of force was to be prohibited in international relations. So we have this prohibition, and there are a lot of elements that are implicated in this definition. This is a very contentious, maybe one of the most contentious elements of international law, the prohibition of the use of force. And one of the most contentious elements is the scope of the prohibition. So when we talk about force, there are many meanings that this word takes on. For instance, you can talk about the use of lethal force in the context of international human rights law. But this is not what this article is referring to, because this is referring to the resort to force in the international relations of states, which is to say that this article prohibits the resort to force between states in, let's say, as a mechanism or as a method of international relations, as a political measure. So the essential concept here is the use of force from one state against another, or in other words, across an international border. So the use of force by a state against its own nationals or foreign nationals within its territory is normally not considered to be falling within the scope of this prohibition. There are other rules that deal with it, particularly rules of on the protection of human rights. And we have, of course, the general paradigm of state responsibility. But here we're dealing specifically with other subjects. And as you may also well know, when you study this subject, The prohibition on the use and threat of force under Article 2.4 is widely considered to be a norm of a predatory norm of general international law, which is to say a norm of jus cogens. And once again, as you probably know from the previous sessions, a jus cogens norm is a norm that does not allow for derogation by treaty. So it is non-negotiable. It is an absolute prohibition, which its own exceptions are found within the norm itself. And the parties cannot contract out of it. So in this context, it is very important to point out that this rule has very, very many ramifications. So for instance, we find the concept of the crime of aggression in the context of Article 8 bis of the Rome Statute. We will address that later. And also tomorrow, because we have international criminal law. But it also has ramifications, for instance, very interesting connection with international space law. There is a jus cogens norm, one of the other jus cogens norms that are normally considered to be as such, that says that it is prohibited for a state to have to impose national appropriation over celestial bodies. It is widely considered that this norm, which is found in customary law and also in treaty law, in the 1967 Outer Space Treaty, it is considered that this norm is jus cogens because it is derived from the prohibition on the use of force, because the non-appropriation rule is intended to prevent disputes that are liable to bring a threat to international peace and security. So we have a prohibition on the use of force. And so
we have a question.
Sorry. Oh, go ahead. Yeah,
we have a question. It says, so it would be right to say that non-international armed conflicts do not fall within the scope of prohibition, as IHL would rather regulate non-international armed conflicts.
More or less. So I will explain that subject now. So what we're dealing with here is a concept that is called jus ad bellum, the law that governs the cases in which the state can go to war. When we talk about international humanitarian law, we are dealing with another body of law, which is jus in bello, the law that governs the conduct of hostilities, and which, as you know, governs international armed conflicts and other forms of conflicts, such as non-international armed conflicts. So the concept here, and you will find it also when we talk about self-defense, is that there is a very close connection between the use of force and international humanitarian law, because the resort to force between states brings into life an international armed conflict. And so there are certain international humanitarian law obligations that have to be considered when a state uses force, because just because it is operating under the scope of jus ad bellum doesn't mean that the state can operate in a manner that, for instance, violates the principle of distinction in international humanitarian law. So there is a connection. But when we talk about non-international armed conflicts, there is a different understanding, which is to say that this is a dispute that does not involve a dispute between two states. That is to say, one state against the other one, but rather we are dealing with a state and a non-state actor, or between non-state actors. And because when we talk about international armed conflicts, the prohibition on the use of force is absolute and is jus cogens. It is considered that any use of force in itself is sufficient to bring into operation the rules of humanitarian law. But when we talk about non-international armed conflicts, because there is no such prohibition for non-state actors to attack each other, that is to say, or for a state to attack a non-state actor in itself, as we find in the charter, then it is understood that there needs to be a level of intensity. And this was pointed out in the Tadic case of the International Criminal Tribunal for the former Yugoslavia. So there is a connection between the two subjects, but it is very important to distinguish between their separate functions, because otherwise there are some rules that do not apply in the other body of law, and they have separate purposes in the context of international law. I don't know if that assuages your concern. I believe it does. Oh, great. Okay. So, and also you saw in the first slide my email address. So if you have any question that is outstanding, you can send it to me through email. I will be open to that. So force, the concept of force is very straightforward. We are essentially dealing with military force. The gravity and intensity of the military force will vary from case to case, but we are dealing with military force. There is some move in multiple political fora for economic coercion to be encompassed within the concept of force, sort of an economic aggression. So this concept is not yet crystallized in international law. There is not overwhelming support for it. And this is because economic coercion and measures of economic nature which do not implicate the use of force, but which constitute coercion and which may in some ways violate a rule of international law, are governed by other rules. For instance, economic coercion may in some instances be considered an act of intervention, which violates customary international law. It may also infringe on human rights. It may also infringe on sovereignty if the concept of sovereignty is understood in this way. But it is not widely accepted that economic aggression falls within the prohibition of Article 2.4 of the Charter. So let's see. There is also the distinction in Article 2.4 between the use of force on the one hand and the threat of force. And essentially, the distinction is there because it is understood that while we're talking about the use of force, we are talking about an actual exertion of military force from one state to another. While when we're talking about threat of force, in the words used by the International Court of Justice in the Nuclear Weapons Advisory Opinion of 1997, we are talking about the actions and statements of a state that signal the intention to use force. And so this is also prohibited by Article 2.4. And the court analyzes a little bit of this subject in the Nuclear Weapons Advisory Opinion. And the court tells us that there is a relationship between the threat of force and the use of force, in the sense that if the underlying force that is being threatened would violate international law, then so would the threat of it. So for instance, if I threaten another state to act in self-defense, that doesn't violate international law. It doesn't violate Article 2.4, sort of an analogical argument. But if I threaten to undertake an act of aggression, then I would be violating Article 2.4. That is essentially what you find in a nuclear weapons case. And I exhort you to look into this case because it is very interesting. So dealing with the concept of aggression, this is a very sensitive, a very political question. It is also very contested as to what its exact meaning is in international law. So many academic writings, especially when commenting on the Nicaragua case of 1986, the judgment of 1986, have come to the conclusion that there is a distinction between a use of force, light, so to say, an armed attack, which is the concept used in the context of self-defense, and aggression, an act of aggression. And because of some passages of the Nicaragua decision, some academics have come to the conclusion that this is a question of degree. So a use of force is the general concept. An armed attack is a very specific kind of force that is very grave and that involves the sending of troops or irregular forces from one state to another. And then we have aggression, which is like the gravest form of the use of force that you can have. But the test of time this distinction has not quite withstood the test of time, because it is not only a question of justification. And when we want to know about the base concept of aggression, we can look at the UN General Assembly Resolution 3314, which is called the definition of aggression. And the way in which this resolution defines the concept of aggression is as you see on the screen. It tells us that it is the use of armed force by one state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the UN Charter. And so at first glance, you will see that this matches very closely the definition of the use of force, or the prohibition of the use of force in Article 2.4 of the Charter. This is because, of course, the concepts are related. But the resolution goes on to say that the first use of force by a state, which is unprovoked, is prima facie evidence of an act of aggression. And but the Security Council can come to the contrary conclusion if there is specific evidence in the case that points that way, including a lack of sufficient gravity in the use of force. And then the resolution gives us an illustrative list of acts of aggression. So this resolution read in context suggests that the concept of aggression has two different, let's say, criteria, or not criteria, but considerations. We have to consider on the one hand, the issue of gravity, because the resolution tells us that aggression refers to a very grave use of force, although it doesn't qualify that gravity. On the other hand, we talk about a lack of justification. And by justification, I don't mean an excuse or a reason for using force. Rather, I mean an exception. So aggression normally refers to a severe use of force that does not fall within any of the exceptions recognized by international law. For instance, an act of self-defense would not be an act of aggression because international law permits self-defense. Now, if I were to use force in a non-provoked manner against another state, in a manner that violates its territorial integrity or political independence, then I would be acting in an aggressive fashion. So the analysis of what is an act of aggression then must be undertaken in each particular case. But resolution 3314 does give us some parameters as to what is considered an act of aggression. So if you want to go deeply into this question, I would suggest that you look up this resolution. It is very interesting. There's a lot of academic commentary on it. And an interesting element of this resolution is that once an act of aggression is considered to have occurred, no justification of any kind is to be accepted, be it economic, political, religious, social, whatever. No justification is considered to be illicit, and the act is considered to be absolutely prohibited by international law. And this comes back to the question of how this prohibition falls within the concept of jus cogens. It is a prohibition from which no derogation can be permitted. And so there is no justification for it. So as you can see, it is a very, very, very rich, very interesting, but also very complicated question. And the underlying issue that we will be addressing then is that there is a severe use of force that does not enjoy a justification permitted by international law. It is aggressive, not defensive, and not authorized, as we will see later. And this has a very close connection with the concept of the crime of aggression. We will delve into the concept of the crime of aggression in tomorrow's session, because this is a crime, a core crime recognized under the Rome Statute of the ICC. But it is, just to briefly address it, it is a criminal prohibition found in Article 8 bis of the Rome Statute, and it is defined as an act of aggression, or rather the preparation, undertaking, and execution of an act of aggression that by its nature, gravity, and scale constitutes a manifest violation of the UN Charter. And you will find in paragraph 2 of Article 8 bis that there is an enumeration of acts of aggression which identically maps resolution 3314, because that is where they drew it from. So we will move on to now the question of exceptions. So this question of exceptions is complicated. And those that have studied the law on the use of force know it. Those that haven't will know it when you analyze any case, any Jessup case, essentially, because almost every case of Jessup has at least one element of this. So I want you to very, very deeply analyze this subject, because it is fraught with controversy and it is fraught with dispute as to what is exactly considered to be an exception. And the reason for that is that the prohibition of the use of force is so hallowed and so respected and so serious that states do not take lightly the assertion by anyone that there is a new exception, because it can endanger international peace and security. So there is an interest of construing exceptions very narrowly. And this intent will be seen very clearly in both of these exceptions. So what you see on the screen are two exceptions, which are self-defense and Security Council authorization. These are the only exceptions that are widely accepted to be exceptions, that don't have much retraction. Self-defense is regulated in Article 51 of the UN Charter, which is found with the Chapter 7 of the Charter. And Security Council authorization is found in the preceding articles within Chapter 7. So self-defense, we will first deal with self-defense. Self-defense is considered to be an inherent right of the state. It is a natural right. And in fact, some of its earlier characterizations can be found in cases such as the Caroline incident and also the Kellogg-Briand Pact I mentioned before, because many states that accepted this treaty made an exception regarding self-defense. So they said, we prohibit the use of force, but we do not consider it to be prohibited for a state to use force in its own preservation. But because it is such an, let's say, an abstract concept to use force in your own preservation, there are very strict preconditions for the use of force in this instance. So the first, and this is very important, is that self-defense can only be undertaken in response to an armed attack, or what the French version calls an agression armée, an armed aggression. So it has to be in response to a very grave use of force. If the use of force does not rise to the level of an armed attack in the context of Article 51, you cannot use force to respond to it. You have to use other mechanisms. If there is a minor border dispute between the states, you cannot use force in response because it would be an act of aggression, or rather a violation of the use of force prohibition. So that is the first. There has to be an armed attack. Here is where there have been some discussions as to the existence of a rule of international law that permits anticipatory or preemptive self-defense. These are not completely accepted. The ICJ has not come to the conclusion that they are part of the definition of self-defense as found in Article 51, although it has been pointed out that there is some state practice that points in this direction. So it is contested whether you can take a self-defensive measure in anticipation to an armed attack that has not yet occurred. So that is the first point that needs to be made. But the essential element is that there needs to be an armed attack, an armed aggression. Then the state has to act in its use of force in response to this armed aggression in a manner that is necessary, which is to say that you only resort to force if it is the only way to respond to the armed aggression. It has to be the only way. If there are other means, for instance, diplomatic means or economic means, sanctions, whatever, you cannot use force in self-defense. So it is a very narrowly construed concept. I think we have a question. I will address it now because I think it has to do with armed attack.
It says, pertaining to the first precondition, does the armed attack have to meet a specific level of gravity?
So the findings of the International Court of Justice in the 1986 Nicaragua case does suggest this. But the definition of an armed attack given by the court in that case is that there is an sending on behalf of a state of armed forces or irregular troops from one state against another. So the concept in itself encapsulates a situation in which a state has mounted an armed aggression or an armed intervention against another state. So for instance, the throwing of a missile from one state to another would be an armed attack because it rises to that level of gravity. On the other hand, for instance, the crossing of a single soldier by accident might not. So there is an element there of gravity. And as I mentioned, if you do not reach that element of gravity, then if you don't find an armed attack in the case, then there is no right to resort to force in self-defense. You have other mechanisms, such as for instance, the resort to countermeasure. And as a follow-up, I see that you're asking about rebel groups. So yes, you can. And when you talk about rebel groups, you have to come back to the rules on attribution. So long as the state is responsible under international law for the actions of the rebel group, then we would be in this concept. So the 1986 Nicaragua case tells us that an armed attack is descending by or on behalf of And in the context of the Nicaragua case, what the court addressed was the effective control. There needed to be effective control over the rebel group. Because otherwise, as you know, the actions of non-state actors are normally considered not to bind the state unless there is a cause for attribution. But in principle, a rebel group could be the perpetrator of an armed attack that is attributable to another state. And this is a very important question. I would like to highlight that because there is a move within the academic world, and in fact, in state practice, trying to justify the use of force in response to an armed attack by a non-state actor in which that attack is not attributable to a state. That is to say, the right to self-defense against non-state actors. And this is far from being established as a rule of customary law, much less a rule of jus cogens. In fact, the International Court of Justice has been able to reach conclusions on this respect. In the 1986 Nicaragua case, in 2004 Wall Advisory Opinion, and I believe I remember the year, I think 2002, Armed Activities Decision. And the court says that if there is no attribution, that is to say that the armed attack is not by a state or on behalf of a state, then there is no right to self-defense. And this has been the subject of a lot of debate. So I would encourage you to look into it because it is very interesting. And it has been the object of many discussions, both inside and outside the Jessup community. We have necessity, which, as I mentioned, means that you have to use force only if it's the only means to respond to the use of force against you. And then you have proportionality, which is to say that the force that you use has to be proportionate to the objective of the self-defensive measure. You cannot use more force than is proportionate to the force that is being used against you, because otherwise you are acting in an aggressive manner. You're acting excessively. So there has to be proportionate as well. And finally, the state has to comply with environmental and humanitarian obligations. So for instance, if this was addressed by the court in the nuclear weapons advisory opinion, in which the court said that the throwing of a nuclear weapon against another state would be an armed attack normally. But when addressing whether a nuclear weapon could be used as a response, the court says that the question of proportionality, necessity, etc., had also to take into account the environmental impacts of a nuclear weapon, and also the implications for the principle of distinction, the principle of the reduction of suffering. And so when acting in self-defense, states have to take into account these considerations. And to close the question of self-defense, there is also, what I talked about right now is individual self-defense. There is also the concept of collective self-defense. Oh, and I see that there's a question for the principle of distinction. I can address it briefly, but remember that we will address this in tomorrow's session because it is a principle of IHL. The principle of distinction says that combatants cannot use force indiscriminately against combatants and non-combatants. So in undertaking any military operation, combatants have to distinguish between civilians and non-civilians. The use of force directed against a civilian would violate IHL, and that is the principle of distinction. So we have the concept of collective self-defense. Collective self-defense basically means that there's a group of states that act in assistance to the state that is defending itself. But in order for this to be possible, that is to say for a state to use force in behalf of another state, there has to be an invitation. The state that is being the victim of an armed attack has to expressly ask for collective self-defense. Otherwise, it is illegal. It is an act of intervention that violates the prohibition on the use of force. The second one, which I will address very briefly, is Security Council authorization. This is regulated in Chapter 7. It is one of the pillars of the peace and security mechanism of the UN. And essentially, it means that the Security Council, when it is encountered with a threat to the peace, a breach of the peace, or an act of aggression, it can undertake forcible measures. And these are not illegal because they are authorized by the charter itself. This was recognized by the court in the nuclear weapons advisory opinion, that they are an exception to the use of force. So I mentioned the preconditions, which is a threat to the peace, a breach of the peace, and an act of aggression. The concepts are very self-explanatory and they overlap. So it really depends on the particular situation at hand. And the resort to force has to be proportionate to it is generally considered to need to be proportionate to the gravity of the situation. As to the scope of action, the Security Council can undertake many measures. It can take preventive measures before the breach of the peace has occurred, or it can actually send aerial, maritime, and land forces, which are provided by states on a voluntary fashion. So in this concept, and I will offer some reflections about the so-called UN collective security system. So Article 51 of the Charter, when it talks about self-defense, it tells us that the state using self-defense has to notify the Security Council, and it has to suspend its self-defensive measures once the Security Council has taken an action under Chapter 7. This tells us that self-defensive measures are not only temporary, they are also exceptional. And the reason for that is that the notion of force in the Charter of the United Nations is understood to be a prohibition that only has collective exceptions. You have a collective system of security, and the right for individual self-help measures in response to armed attack is limited, is very subject to conditions, because otherwise the whole security system would collapse if every state were to use force unilaterally. So the intent is for collective threats to peace to be addressed collectively. And that is why the Security Council has authorization to use force. I will address very briefly two subjects, and then I will conclude this part of the session so that tomorrow we can address the more detailed aspects of humanitarian law, criminal law, and human rights. The first subject is the existence of disputed exceptions to the prohibition on the use of force. The first is the concept of unilateral humanitarian interventions, which essentially means I use force not in response to an armed attack against me, but in response to a humanitarian situation that has gotten out of hand. So the purpose is to protect and safeguard human rights of a population that's being the object of abuse and systematic violations of human rights, where the state itself is rather unwilling or unable to prevent that. So in this case, it is essentially the same as a UN Security Council authorization, use of force, but it doesn't have authorization. So the general understanding in the international community is that unilateral international humanitarian interventions are acts of aggression. They are prohibited. Of course, there are some states that support that there is a very narrow exception for humanitarian interventions, and that is still the object of debate. We will most likely find some analysis in this respect in the most recently initiated allegations of genocide case between Ukraine and Russia, because the claim brought by Ukraine is that Russia cannot use force as a mechanism to repel acts of genocide. And there is one passage in the preliminary objections case, which is very recent, in which the court says that prima facie, and for the purposes of determining whether there is a right that is being for Ukraine that is being violated in the case, prima facie, the court comes to the conclusion that the use of force is not a mechanism to prevent or punish genocide. So take that for what you will, but it suggests that the use of force is not a sound mechanism to respond to massive human rights abuses. The court has not taken a decision in this respect because it is a provisional preliminary objections decision, but it is very interesting. The other ones that are disputed are the, sorry?
There's a question saying, is the Ukraine versus Russia genocide case from the ICJ?
Yes, it is. It is the most recent one.
But it's,
it was initiated as a response to the use of force by Russia against Ukraine that is currently ongoing. And it was a case initiated by Ukraine against Russia, alleging a violation of Article 1 of the Genocide Convention, because one of the arguments made by Russia is that the use of force is motivated by acts of genocide, alleged acts of genocide. So the case has not come to a final decision, which is why I tell you that what I tell you on this case has to be taken with a grain of salt. but there is a preliminary objections case, a preliminary objections decision, in which the court seems to point to the conclusion that unilateral humanitarian interventions are not permitted under the Genocide Convention. Now, this is not yet, as I mentioned, come to a final decision. So this may be contradicted in a subsequent finding by the court, but it is interesting. We have, as a subsequent disputed exception, the use of force against non-state actors in foreign territory, which is basically the use of force against terrorists in another country without the consent of the territorial state. And in those cases, some states have posited the position that there is an exception to the prohibition on the use of force. This exception is not widely accepted. An act of a use of force against another state, regardless of the reason, other than the accepted exceptions, will normally be considered an act of aggression. So this exception is not widely accepted. And if you're interested in learning more about this, I really, really recommend our book that was recently published by Diret Ladi, who is a member of the ILC. The book is actually called Extraterritorial Use of Force Against Non-State Actors. It is published by Brill, the Brill editorial, and it is very good. It is the result of the Hague Academy courses of last year. So if you're interested in this analysis, it is a very good book on it. And finally, oh, I see we have a question. Oh yes, I will write it down. It is the extraterritorial. I wrote the information there. So the final exception, which is disputed, is consent. But I will make a caveat here, which is that it is not that consent is not considered to be an exception, or rather the consent is not recognized as a possible cause for excluding responsibility. Rather, what the academics say is that it is not an exception to the prohibition, because when there is consent, there is no force. So if there is consent by the state and the military action falls within the scope of the consent, as is found in article, I believe, 20 of the ILC articles, then there is no force against that state. And therefore there would be no need to examine whether it is an exception or not. It is simply not wrongful. But it is generally accepted that if there is consent, there is no breach of Article 2.4 because there is no force in a strict sense. So as a final point, I will address the role that is played by the UN General Assembly. So the UN General Assembly within the UN framework does not have the authority to permit or allow for the use of force. That is basically the rule. It is only the Security Council that has that right. However, there is one resolution, which is UNGA resolution 37.7A, which is called the Uniting for Peace resolution, which basically says that when the UN Security Council is barred from action due to a veto right exercised by a permanent member, the UN General Assembly can desist immediately of the matter and can recommend, and I stress this, recommend collective measures for the protection of international peace and security. This could go either from recommending embargoes, for example. It could be recommending, for example, condemnation, recommending the closure of borders, etc. But they are recommendations, and states decide if they take them up. One example of this is in the context, once again, of Russia's aggression against Ukraine, because when the Security Council was unable to take a decision condemning the act of aggression, the UN's General Assembly was immediately seized of the matter, and it issued a decision on a resolution on the 24th of March of 2022, based on the Uniting for Peace resolution, calling and condemning the armed attack by Russia as an act of aggression in violation of Article 2.4. So this was under the scope of the Uniting for Peace resolution. And this is a measure by the UNGA condemning the use of force, even though the UNGA cannot in itself take peace enforcement measures. It can, with the consent of the territorial states, take peacekeeping measures, but that is about it. And in fact, there is a move. This was especially pushed by Liechtenstein and the United States, that the Uniting for Peace resolution should be applied strictly, in the sense that in the context of this crisis in Ukraine, the armed attack in Ukraine, that every time there is a decision barred by a veto right in the Security Council, the General Assembly should be called and seize of the matter and immediately decide on it in the concert of all states. So the Uniting for Peace resolution is taking a lot of importance right now. So that concludes my presentation on dispute settlement and the use of force. I don't know if there are any further questions that you would like to pose.
No, I don't think so.
Great.